it's not only the final decisions that are important under the Open Meetings Act, but that the public body see how you came to these decisions, what deliberations were made, what issues were considered. So that is really a good framework for understanding why a lot of these provisions say what it is that they say. The first thing that you need to do is though figure out if the Open Meetings Act applies. In order for it to apply, a quorum of a public body must have a meeting. So there's 3 threshold questions you must answer. Is this a public body? Is there a quorum? And is this a meeting? The Open Meetings Act defines a public body on page 24 as any department, agency, commission, committee, board, council, bureau, or authority of any subdivision thereof for state or municipal government. Something that you should notice about this is that although it still is a fairly broad definition, it's actually narrower than the definition Mike gave you during the Public Records Act because it does not include bodies acting on behalf of or in place of the public body. Another thing, though, that I want you to note is that the OMA expressly includes subgroups, subcommittees, working groups, and that all of these subgroups must follow the provisions of the Open Meetings Act as well. And that's because of the purpose that we just discussed, so that members of the public can see what you went through in order to get to the decisions that are eventually made. The second threshold that must be met is that there must be a quorum. This is a fairly straightforward definition, which is a simple majority of the membership. A public body may otherwise define this or some other version of a quorum, but normally it will just be a simple majority. This year, we issued Kenny versus the Hopkinton Town Council, in which 2 members of a 5-member town council had a discussion about business that related to the town council. Because it was only 2 people, and they needed 3 to have a quorum, we found that the quorum provision was not triggered, and therefore the Open Meetings Act could not apply. However, this is an instance that brings us into our next slide, which is the rolling or walking quorum. Had either one of these people after the fact had a discussion with the 3rd member, then 3 members of the public body would have discussed the same issue that they had jurisdiction over, and it would have been a rolling or walking quorum, despite the fact that all 3 people would not have been in the same place at the same time. Other ways that this can easily occur are when public body members have conversations by email or even by faxing documents back and forth between each other. So even though members of a public body may not be physically present with each other, that does not mean they can't violate the Open Meetings Act by establishing a quorum. The third threshold question that must be answered for the Open Meetings Act to apply is that there must be a meeting. A meeting is the convening of a public body to discuss and or act upon a matter over which the public body has supervision, control, jurisdiction, or advisory power. And what is most important about this is the type of matter they are discussing. So for instance, if a public body got together and went out to brunch together, or even went to an awards banquet, and even if the whole body was there, as long as they only discussed matters that did not relate to the business that they are charged to discuss, this would not be a violation of the Open Meetings Act. A meeting, however, does expressly include workshops and work sessions, and again, that gets back to the purpose, which is that the deliberations are also important. A case that we decided last year in 2009, which is actually several slides back in your handout, but it's Parks versus the Cumberland School Committee. In this one, this is an issue that's been coming up more. 2 public bodies had a meeting together. One of the public bodies, the town council, properly noticed the meeting in accordance with the Open Meetings Act, but the school committee did not advertise this meeting. There was a quorum of the school committee there, and some of the business they discussed pertained to the school committee's business. So even though they said, well, this is a town council meeting and we were just there for them, because there was a quorum of the public body there and they discussed their business, this constituted a meeting under the Open Meetings Act, and the school committee was in violation for not following the procedures of the Open Meetings Act.
When we talked about the public record law, we talked about really the premise starting with everything was public record, unless it fell within one of the exceptions. The same principle really applies to the Open Meetings Act. Everything is presumed to be in public. There's a presumption that it's an open meeting unless it falls within one of the 10 exceptions. We'll talk about this in a moment. Before we talk about the 10 exceptions, or at least some of the exceptions for executive session, I wanted to talk about how to get into executive session. Convening into executive session. Public bodies, in order to go into executive session, have to articulate and record what's called the open call. It's by majority vote. Majority vote of the public body has to vote to go into executive session. And they have to cite the statement, cite the citation and the statement for the reason going into executive session. Some of the areas that we've seen over the last year or so, one of the big ones, and we talked about this at past Open Government Summits, but we're going to talk about it again because it's really important, is some public bodies going into executive session under one exception and discussing multiple matters in executive session under either that exception or under other exceptions that weren't even cited. Be really, really wary of this. It violates the Act, the Open Meetings Act. It's one of the more important violations because the public may not even know that you're going into executive session at all to discuss this matter. And when we're reviewing the executive session minutes, that's really when it comes to light for the first time. And that's a big problem. To make clear, if you're going to discuss, let's say, litigation under the second exception, and your agenda cites executive session A2, litigation, that's a suggestion and an implication that you're going into executive session to discuss one matter in executive session and that it relates to litigation. If it pertains to two matters, perhaps, or two citations, but one matter, your agenda should make clear that you're going in under, let's say, A1 and A2 to discuss one litigation matter, or articulate the different litigation matters if there are going to be multiple litigation matters. But somehow your agenda needs to make clear that each citation and each statement pertains to one topic being discussed in executive session. We often get the question about how specific the statement of the nature of the business to be discussed is going to be, has to be. And Laura's going to talk about in a couple minutes about the Tanner case, which is a Rhode Island Supreme Court case from 2005, which pertained to open session. But you see cited here the 1999 case that we issued, and that pertained to executive session. And the test that we've articulated is that for executive session, if the matter to be discussed in executive session is publicly known, it has to be stated more specifically. If you're going to discuss a search committee situation, where that search committee situation is already known, it should be more specific than just personnel. If you're going to discuss litigation that's already been filed, you should cite the name of the case. If you're going into executive session to discuss something that's not publicly known, a broader type of reference may be appropriate. Just citing litigation, just citing personnel. So that's a little bit of a fact-specific situation. And the last bullet point here, not discuss any other matter, even if it would be appropriate for executive session. And this kind of relates to the first point that I was bringing up. What's appropriate to discuss in executive session is only what you've articulated in your open call to go into executive session for. Even if it would be appropriate to discuss a matter, let's say personnel, but it wasn't cited on the agenda or in your open call, it cannot be discussed in executive session. We saw a case like this where an agenda in the open call articulated that they were going to go into executive session under the first exception, A1, which is for job performance, but for the statement specifying the nature of the business to be discussed, it indicated legal matters, which was the second exception. We found that that discussion violated the Open Meeting Act because it wasn't consistent with the citation. So make sure that your citation and your discussions all line up. The first exception, you see that a public body can go into executive session for discussions relating to the job performance, character, or physical or mental health of a person, provided that that person receives advance written notice that they can have that executive session discussion held in open session. Again, one of the more important provisions, the person has to receive advance written notice that they can have the executive session discussion in open session. It doesn't work the other way around. If the public body, I guess to take a step backwards for a second, Laura talked about with the Public Record Act, that just because something's exempt doesn't mean the public body can't provide access. They certainly can provide access, they just don't have to provide access. Or the law doesn't require them to provide access. And the same premise is under the Open Meeting Act. Because something falls within one of the 10 exceptions, doesn't mean the public body has to go into executive session. It only permits the public body to go into executive session. So I just stated that if an executive session is going to occur, that person has the right to have the executive session in open session under this provision. The converse isn't right. If it's going to be held in open session, that person does not have the right to have it in executive session.